So I want to start with OFCCP, and it's not because I don't have a number of questions for everybody on the panel, but the chair has had us under strict instructions to try to keep as limited as possible, and I'm hoping that I'll be able to get some time around to get to everyone else. So I am very excited, Acting Director Lean, that you are focusing on the issue of disabilities. I very much agree that it's an area that has a lot of work to be done, particularly in corporations, to make sure that people with disabilities are given the full opportunity to contribute their talents and to be able to make their way in the world. So I'm very excited about that. I am very interested in your approach on trying to get corporations to live up to their requirements as federal contractors to have, in fact, affirmative action plans in place. So look forward to your experiment, but I'm very interested in understanding more. My understanding is that with this focus under the new procedures, that OFCCP will be sending out a number of letters, scheduling letters, and if the company responds that they have an affirmative action in place, then they will be taken off the schedule for a visit. So I just want to understand if that's correct. If they self-certify that will be enough for you. In the past, I understand that OFCP investigations have often found that while a contractor might have a plan, they rarely had a plan that didn't have significant violations because it is very technical. They're required to look at a lot of data for all races. They need to evaluate their hiring against their actual recruitment, and they need to make sure they're evaluating all job categories. So how do you intend to move forward, and have I completely misunderstood how this process is going to work?
Thank you very much for your question. I appreciate the opportunity to clarify that. We find technical violations about 25% of the time, and we find discrimination about 2% of the time. And you are correct that we are going to try to achieve 100% compliance with affirmative action programs throughout the United States. And we will be having a compliance check process to see that companies that certify that they have an affirmative action program actually have them. But just because you have one doesn't mean we won't review you. We're still going to have our typical scheduling list. And I'm hoping in the last couple of years, it's gone down to about 1,000 or so per list or per year. And I'm hoping to increase that to about 3,500, which would include the focus reviews and then the compliance checks we're also looking at doing. That may be a different subset because we're really dealing with two different issues. One, we want to make sure that everyone has affirmative action programs in place. That to me is basic compliance. And I feel like we can make a really big impact. If let's say in the GAO report, one of the concerns was that when we list a company, they typically have 30 days basically to provide us their affirmative action plan and when they receive the scheduling letter, and then they're requesting an extension. And all they really have to turn over there is the affirmative action program and certain information that they're supposed to keep and update on a yearly basis. So it begged the question, well, if so many of these companies are requesting this extension, do they really have everything in place that they could just turn it over? So we are focusing on that. That's something that we have to address to really ensure comprehensive compliance. We're still going to be doing audits, though. Even if you have an affirmative action program, you could still end up on the list. The 3,500. That's going to be comprised of focused reviews and also our typical compliance evaluations, which are more comprehensive. But we are still going to be doing that. I want to be perfectly clear. Just because you have an affirmative action program and certify it, you could still be listed. We publish our scheduling methodology now, and we'll be publishing it going forward. Companies will be able to see how we chose them, and they will see that we're acting fairly and that we're applying neutral principles, which we're required to do. And we are also publishing now the list of everyone that is being audited so that there's clear transparency. So does that answer your question?
That helps. Thank you. Also, and you may not have this data with you, so feel free to tell me that you can submit it later. How how many compliance investigations have been initiated since 2016, and how many of the new compliance investigations have found discrimination, and how many damages and recoveries have been submitted for FY 2017 and 18?
I'll have to get back to you with the specific numbers, which I will. Let me answer that generally. We've been doing about 1,000 a year in the last couple of years. I feel that's gone down over the course of time. And we used to do something like 5,000 about a decade ago. So we're trying to, and I think one of the ways that happened was in the prior administration, there was a decision to reduce the total amount of audits and focus more on those that are audited. It's something called the deep dive, and which has received both positive and negative responses. So our goal, and we're going to be actually publishing a directive on this at some point, our goal is to take the best aspects of what's called active case management, which is really the Bush administration approach, which had more audits, and active case enforcement, which was sort of the Obama administration approach, which led to less audits. By the way, both of which found discrimination about 2% of the time again, to try to increase the amount of audits, but also do it in an effective way, because we do want to continue our commitment to enforcement of anti-discrimination principles based on race and gender, including in the compensation area. I mean, that's key. We go where the numbers tell us. We're doing statistical reviews. I mean, just in case some here don't know, I'm sure you all know what we do, but we do regression analyses. So we get information regarding the compensation of basically everyone within these job groups at a company. And we do a statistical regression analysis to see if there is a gap in pay that cannot be explained by one of our controlling factors, a legitimate factor based on race or gender. And if we find a disparity more than 2 standard deviations, we still will go on site. We will review that. We will send supplemental information requests, and we will enforce. In terms of the amount of recoveries, I want to get you the exact numbers, so I'm going to just give you a general figure, and I'm sorry I don't have the specifics. In FY17, we were in the low 20 millions, which was the highest year on record, is my recollection. In FY18, we were in the mid-teens, which was the 3rd highest year on record. This upcoming year, we have some big cases. We're hoping to be able to get either some substantial settlements or go forward with enforcement. And some of them are in enforcement right now, and they're known in the public record. We are committed to those cases, and we think that we have a good chance in this upcoming fiscal year to have the largest year on record by a fair amount.
Great. So along with those big cases, the Department of Labor recently rescinded a settlement with Microsoft to resolve an investigation after a finding that the tech company had paid women in engineering and other unspecified tech jobs less than their male coworkers and passed them over for promotions. To Secretary Acosta's credit, he was concerned that the proposed settlement was not sufficient, is my guess. What is OFCCP doing now to ensure that they're fully holding these kinds of companies accountable?
Well, I need to say something before I answer the rest of the question. I cannot comment on that specific matter. Now, the more general question of what are we doing to ensure that the settlement amounts are appropriate when we resolve matters is we've done a couple things. One, we've issued a directive that's called a PDN directive, the Preliminary Determination Notice Review. So one critique that's been done of OFCCP is that one, that we weren't that transparent an agency, and 2, that you would get different treatment by different regions. And when you come into these situations, it's often hard to assess, is that correct or not? We do look at the numbers, and we're trying to make sure that the numbers, the stats, are similar with the different regions. But in terms of whether you're getting basically being treated differently in a review by the Southeast region versus the Pacific region, my main approach was, well, look, let's assume that that's happening. What would we do if it was? Because it's always good to do reviews internally and to set up appropriate procedures. So what we've done is we issued a preliminary determination notice directive. What it says is that companies, early in the process, we will let them know what the disparities are that we found. They will have an opportunity to respond before we issue a a notice of violation. We've encouraged companies to actually respond, give us a comprehensive response. It's good for us too in terms of use of governmental resources. We want to know, do they have a strong defense or not? Or are we missing something in the way that we're reviewing the numbers? We give them that opportunity, they respond. That's reviewed both by the region and the national office to ensure that we have quality control. At that point, we would issue, we would either amend our findings based on the response and the additional information they provide, and issue the notice of violation. Or we wouldn't change it if we find that they don't have a good response, and we would issue the notice of violation. Or conceivably, if they convince us they haven't been discriminating, we wouldn't issue the notice of violation. That hasn't happened yet, but that third category, but it's possible. And I want companies to know that that is possible, so they should respond. We're trying to add a degree of due process to the administrative aspect of our cases. And then in addition to that, it allows us to see, do we have quality control in the way that we're reviewing these cases? But I want to tell you, we are committed to appropriate settlement amounts. And by appropriate settlement amounts, there's two components. One, we expect 100% prospective relief. We're not going to agree to a settlement which allows discrimination to continue. I mean, that's a core principle. In terms of back pay, we will try to reasonably settle it, knowing that a lot of times there are a battle of experts going on. There are two different perspectives. One of the critiques of OFCCP has been that we don't, am I talking too much?
Well, it's just I have another question, and she's going to bang the,
to other people first.
she's going to bang the gavel on me.
Bang.
I have just one more question on LGBT issues.
Not yet. We'll see how others are doing. I understand Commissioner Yaki has a question. He's on the phone.
Okay. See. Sorry, gavel.
Sorry, I didn't.
Sorry.
I have a lot to tell you because we're doing a lot of things.
We appreciate it. Commissioner Yaki.
Thank you very much. I just wanted to first mention in response to a comment by a previous commissioner that I actually shared the viewpoint of one of our panelists about the lack of response of certain agencies to this commission's hearing, because I do remember quite well the amount of time spent by the Department of Justice in responding to this commission when I was on it. I've been on it for quite a while, with regard to the Black Panther Party investigation, including the attendance for essentially the entire day of the Assistant Attorney General for Civil Rights at the time, Mr. Perez. And I think at some point, the amount of information that the department provided to us in response to our interrogatories is a testament to their tolerance for a lot of what we were trying to do, and the lack thereof of this administration in responding to what is really a non-targeted but just very basic exploration of their duties as agencies in enforcing civil rights is actually, in my view, quite astonishing, given the fact that throughout the time when I was on the small number end of a 6-2 majority, with both Republican and Democratic administrations, I do not really remember at all the scope and lack of cooperation that we've seen in this hearing, especially with regard to an issue that we cannot really raise here. But I'm going to ask someone who did have a pre-existing experience with this to talk about. This goes to Secretary Duncan, because obviously one of the agencies that refused to come here, Health and Human Services, is considering some rather drastic revisions, at least according to reports from inside and outside the agency, to the definition of transgender and what impact that would have on transgender people, citizens, residents in this country. And Secretary Duncan, your department dealt with the issue with regard to access to restrooms in public schools, and I'd just like you to comment on your view and opinion of what you believe the impact of the HHS ruling and indeed also the Department of Education's reversal of your policy as it pertains to the transgender community?
Sure. I think we always have to go back to sort of first principles and values. I talked about the two core things that the Department of Education, which I think fundamentally must be a civil rights agency, has to do is to ensure everyone the right to have a high quality education to allow them to fulfill their extraordinary potential. And I always say, no one ever calls the Office of Civil Rights on a good day. They call the Office of Civil Rights when every other recourse, every other chance to get relief has failed. So Catherine and I had a lot of tough meetings, a lot of tough issues. That's just the nature of this work, and we embrace that. But I will say some of our toughest meetings were with transgender students and their parents. And not to be too graphic, but to hear kids talk about urinary tract infections because they don't feel safe to go to the bathroom, to hear about the ridicule and the pressure they felt from others. I think any of us would struggle at our jobs if we couldn't go to the bathroom during the day. It's hard to receive a high quality education if you can't do that. And there's some fundamental things in terms of our students' psychological and social and emotional safety that have to be building blocks before we can start to talk about AP chemistry and physics. And we deny those opportunities when children are literally just trying to survive. We're denying them a high quality education. So we address that. We have to address that. We have to make sure every single child in this country is safe, is cared for, and then has the ability, is free of fear, and then they have the ability to talk about those higher level learning opportunities.
Thank you. Commissioner Cladney, do you have a question?
Thank you, Madam Chair. I know I promised I wouldn't ask any and cede all my time to you. However,
What's happening?
things change. Mr. Lean, I was wondering if you're familiar with 14C of the Fair Labor Standards Act, sub-minimum wage?
Yes.
I've been reading the Congressional Research Report from 2005, and I was wondering, how has the Department of Labor progressed in investigating those types of cases? Have they or haven't they progressed?
Well, I can't comment directly on that because that's not my area, with OFCCP. So, and I was, I'm here on behalf of the Department of Labor and OFCCP,
So you don't know.
but I don't know exactly. I do know, I have talked a lot about sub-minimum wage with ODEP, the Office of Disability Employment Policy. And I know that that's an issue that's leading to a lot of discussion. I mean, there's really two perspectives, and we're also thinking about this issue. So, any feedback would be helpful. But on the one hand, someone like my daughter, for example, who has very severe autism, may only be able to get a job with a sub-minimum wage. It is possible. That may be her only opportunity. On the other hand, and the other approach, and I'm very cognizant of this because I have seen a lot of discrimination against individuals with disability. It is a segregated work environment. It's not integrated. They are being paid less. And a lot of times, those employees are doing a full work. I mean, they should be paid at least the minimum wage. So we're struggling with that issue too. And so is OFCCP, because we are still looking. We do not want to see, obviously, discrimination against individuals with disability, and that is a encoded provision essentially that allows individuals with disabilities to be paid less than others. So that would be my general comment on the topic.
Ms. Mesikoff? I'm sorry, I have a name nobody
Don't
can
worry
pronounce.
about it.
So the sexual harassment guidance from your department is 20 years old.
Right.
And you updated it last year. And for some reason, it got sent to OMB.
Right. We put out a proposed guidance in January 17 and got public comments, and it was reviewed by OMB. And
Still being reviewed by
yeah,
OMB.
it is still being reviewed.
How long's that
That's
been?
correct. Well, there's been some back and forth and conversation, but it's obviously been about 9 months or so.
How many pages is it?
Well, it's about 75 or 80 pages, about 350 footnotes, but nonetheless, yes, that is a long time. I understand.
And do you have any expectation of a date that it will be issued?
I do not.
Is there a possibility it won't be issued?
I really don't know.
So that is a
It's up in
possibility.
the air. I think it's probably a possibility, but I really don't know.
Thank you.
Madam Vice Chair.
Thank you very much, Madam Chair. This question is for Assistant Secretary Green. You pointed out the power of secretary-initiated cases in combating policies and practices that harm large numbers of people. And you pointed out to us that tight budgets make it challenging to respond effectively to individual complaints, and all of that makes sense. I was wondering if you could tell us about how many secretary-initiated matters have been filed and that you've looked into, and say a word or two, if you know, about how that compares with earlier years and perhaps prior administrations. And if you don't know that, if you could provide that information for us. And then if you could somehow tell us why secretary-initiated cases might not rate being someplace in the priorities that you set out for us.
Can I just piggyback on that and ask you to tell us also what the difference is between a compliance review and a secretary-initiated case?
Sure. Well, let me start with your question, Madam Chairman. Secretary-initiated cases under the Fair Housing Act can involve any entity engaged in a housing transaction. So whether it's sale, rental, lending, advertising, whereas the compliance reviews are typically of government-assisted housing providers. And you could have a secretary-initiated case which also involves a government-assisted housing provider. So it's a very broad authority. In terms of actual numbers, I can get you actual numbers of how many we have currently. I would say it's a handful of secretary-initiated cases. I think what's most important to stress about the secretary-initiated cases is that they are resource-intensive. And I think I speak for many of us that we want to do more efficient investigations of the individual complaints so that we have the resources to take on secretary-initiated cases, to do investigations of areas where we believe there may be discrimination, where we could make greater transformational change. I would say in my time at the department, secretary-initiated cases, we've probably have never had more than 20 at any given time, probably averaging, somewhere in the 10 or 12 range. It all depends. And again, depending on how big the case is, if you have a handful of really big cases, that may be why you have a lower number at a given time than another time where you may have more, but they may not be as resource intensive. But they are, again, really based on the resources we have. I'm pleased that we are becoming more efficient in how we handle the individual cases. So I'm hoping we can take on more of this work.
I have a question that I'd love for all of you to try to speak to. Several of you have spoken very compellingly about the difficulty of managing your resources as against the very broad charges that each of the agencies that you lead or led has. And a couple of you have talked about challenges in trying to make sure that you have consistent results across offices and that your offices achieve the results that you want to achieve. So I'm curious if you could speak to the importance of the federal role, the importance of consistency across the offices, and the ways that you manage consistency in the end results. And in particular, Mr. Rodriguez, you mentioned in your written testimony that you had worked with your staff when you were at HHS to include in the evaluation plans for employees a priority to work on systemic cases as well. And I'm curious if you can speak to the value of going down to the level of how employees are rated in that as a mechanism, among other mechanisms for achieving the results that you want to achieve, and also speaking with the the federal voice to these issues.
Yeah, no, I really appreciate the opportunity.
I think you need to turn your microphone on just so we can get the transcription.
There we go. To address that question, my background is in law enforcement. I was a state and federal prosecutor, and core to the law enforcement mission is establishing a set of priorities of the work that you're going to do. A homicide is always more important than a turnstile jumping. And what I found when I got to HHS OCR was that the way we rated our investigators was based purely on the volume of cases that they completed and not on the impact of the cases that were handled. And as a result, there was actually a fundamental disincentive to pursue a big case, a case with a systemic impact, which struck me as undermining the core mission of the agency, which was in fact not just to do justice in that particular case, and it was certainly that, but then to use that case as a deterrent, as an object lesson. And so both in terms of how we were rating our employees, but then also in terms of how we led them and how we spoke to them, we emphasized the importance, and the results started coming. I was ultimately there, just short of 3 years, in the sense that we were starting to really do the kinds of cases that I thought and that our leadership team thought we should be doing.
Thank you. Ms. Miaskov?
At EEOC, we have both a strategic plan, like everyone has to, and a strategic enforcement plan. And the strategic enforcement plan has 6 priorities. To bring that into reality, we do 2 things. One is that when we do individual evaluations, everyone's functions are linked into those plans, and you have to establish what you as an individual have done in service of those goals. The other thing is that we have quarterly meetings. They're not formally meetings, but gatherings, briefings, where the commissioners meet and talk to the office directors about the kinds of cases that they're bringing, what they're finding, what the results are, progress on these priorities, and what needs to be addressed and what isn't being addressed adequately. So that's on a quarterly basis. And we've also implemented a process where with litigation, a certain percentage, I guess, of litigation from each district actually goes to the commission now that is under the priorities for them to review. On top of that, we have a whole quality assurance plan that's more managerial. But I think the strategic enforcement plan and its priorities are at the heart of everything.
It's very interesting because OFCCP used to have a closed case indicator where we would basically reward performance based on closed cases. And there was a concern that it incentivized closing cases that were even strong. The problem was we removed that indicator, and then our age cases greatly expanded. And when I came into the agency, I was very concerned about that. I do not like age cases. I feel that for a number of reasons. I won't belabor it, but if you are finding discrimination, you need to fix it quickly, particularly with the turnover that exists. And also that means people are living in a discriminatory framework. And a lot of times companies won't fix it until you reach the final settlement. So I feel like it's very important to move cases forward. So we're looking at adopting sort of a combined index matrix that we're working on that does still give some reward for going through a case and closing it where you find a company that's doing the right thing, but that also rewards more the bigger cases, because we remain committed to the large systemic compensation cases. That's still going to be what we're still looking for, those big cases. In fact, we're trying to do it better by focusing on likely violators. So that's in a general sense what we're trying to do.
Thank you.
In the time I've been at HUD, I think we've really, over many years, have often had sort of a tug of war over the issues of volume and getting cases done on a timely basis and achieving the optimal outcomes for individuals in those cases. They are not mutually exclusive, and certainly, when the Fair Housing Act was passed and Congress charged us with completing cases within 100 days, the expectation was that we would get justice for people within 100 days. So I've seen many different ways of managing these metrics over the years. I actually think that currently we've probably managed to balance them best in recent years, in part by shifting how we allocate our resources. Like, we've actually had a team effort working on our age case inventory, which in the last several years has brought down that inventory and has allowed other investigators to focus on the newer cases and ensure that those cases don't age. We have had a number of performance measures that were focused on outcomes and tracking relief. There's only so much you can do in that area, but there you're typically we're using historical data to determine what may be expected of a given region or of individual investigators. But it's a balance, and I think the key to all of it ultimately is also having the staff resources to go in and do quality assurance. That remains challenging. And then beyond what we do at HUD, as I said in my opening statement, 77% of our cases are also being handled by state and local agencies. And so another really important part of our mission is to do the mission oversight there, because now if you're facing discrimination, housing discrimination in the country, you're more likely to be dealing with one of about 89 different agencies. So we're trying to establish consistency in operations across them and devote staff resources to that. Currently, we have 24 people doing that for all of those agencies and several thousand cases.
Imagine that's no easy task. Sorry.
I just wanted to add, just to pick up on what you've been saying, we've also seen a real uptick at the state and local agencies, very significant. And we actually have one professional full-time in every office now devoted to managing that relationship and looking over those cases and doing spot checks and sufficiency reviews, et cetera. In terms of the perennial challenge, I think, of balancing case load, of reducing the backlog versus quality. I think that's sort of a hallmark of this type of work. One other thing that we have started doing is through an online portal for charging parties. We are making an effort to set up sort of gateways that people can sort of self-screen. So people do a questionnaire that's not a charge, but that explores what is the basis of the unfairness that they've experienced, and they can basically see there if they're going to state a claim under one of the EEO laws or not. And then what we do after that is people go into an interview with one of our intake people. And the result of that process has actually been a decline in the charges filed. But because of that, we have more time to focus on ones that really state claims. And we're seeing an increase in our rate of merits resolutions. So we're trying to get more time to focus on the serious cases.
If I could say that's something that we're also looking to do. So Carol and I will be talking more.
Well, that's going to go to my next question, but I saw Secretary Lansing, you were reaching. You just turned your mic off. Yeah.
Three quick points. As I said earlier, I fundamentally believe the Department of Education is a civil rights office, and that every policy decision we made had to be viewed through that lens. So as you know well, we had a team of about 5,000, but we had an executive team of 7 that helped to manage the department on a day-to-day and helped me make decisions on our most difficult policy questions. And the Office of Civil Rights, whether it's your predecessor, Russell Ali, or you, were at that table. And we didn't want the civil rights piece to be an afterthought or to be shoehorned in or tried to shoehorn in the back end or papered over, that it had to be part and parcel of literally every single policy decision we made. And that advice and leadership and counsel and push was extraordinarily helpful. Secondly, this issue of volume versus time, whatever. Just to add one other issue that we haven't talked about is during our time we saw complaints more than double. go from about 5,000 a year to 10,000. And my personal belief, it wasn't that there was that many more nefarious things happening across the country. I think there was a sense that our Office for Civil Rights was open for business. And that increased workload was an extraordinary strain on you and your team. And we felt that in DC, we felt that in our regional offices across the country. We fought hard to increase the number of attorneys who were trying to handle these cases in a thoughtful and fair and efficient manner. To see the current administration actually get rid of civil rights attorneys, I think speaks, it tells you everything you need to know about their values. And I always say budgets tell you values, not words. And when you cut staff, you're walking back those commitments by definition. Secondly, you do have to set some priorities because the volume, again, for better or worse, is large. One concrete example was our sexual harassment task force, which was an administration-wide commitment. So yes, Department of Education at the table, but DOJ, the president, the vice president, all working extraordinarily hard together. Again, given the fact that, decade after decade, survey after survey, 20% of women on campus report that they're sexually harassed. That's a staggering number. That again it's easier not to talk about that or sweep it under the rug, but that reality was one that we tried to take on in a very important way. And then the final thing I'll say is that for education, that obviously so many of our passion for it is our hope that the dream of public education is that it can be the great equalizer. That regardless of race or socioeconomic status or zip code, that if you work hard, you have a chance to do something really special in life. That's the dream of public education. That happens often, but there are too many times when the lack of opportunity actually exacerbates the divide between the haves and the have-nots. And we see the children of the wealthy, the children of the privileged having access to better teachers and better technology and better after-school programming. And so the divide in our country grows because of our unequal commitment to high-quality public education. And been thinking a lot about it. If you're a medical doctor, you have to take a Hippocratic oath to do no harm. I've been wondering what's the educational equivalent to that oath to do no harm.
Thank you. Several of you have spoken to the value of working across agencies and working with each other, including just on this panel now. So I appreciate that. Could you speak to what it is to work across your agencies to try to achieve the civil rights promises and the value or utility of the coordinating authority from the Department of Justice in doing that work as you are today leading the work and as you led it when you were there?
I have something to say about that. A lot of our focus has been on working with the Women's Bureau at Labor, ODEP, the Office of Disability Employment Policy, and VETS for these focus reviews. Mm-hmm. And I'm part of the administration, and what we are doing is really good stuff. I want to be clear about that. We are committed to civil rights. My agency, we are meeting with each of these other agencies and putting together a list of best practices, as well as legally required policies that you need to have in every one of the 10 areas we protect. And I mentioned them before. And, I've met with the ACLU and I met with a lot of groups that come in and I say, here, let me know the policies that we should have. Let me talk to you about the issue of the Women's Bureau. We're working with them on parental leave. I took parental leave when I was an attorney, and I've always fought. And I also had to take a flex schedule at one point because of my daughter's condition, and I pushed for that. And a lot of times, I see discrimination against both men and women in this area. For women, one of the concerns that we have is at some of the, at law firms and financial firms, and I used to work at law firms, sometimes there's a special track for women who want to take, it's not a non-partner track. We're very concerned about that because you should be able to have.
I do want to stay focused on the cross-agency.
Also, we work with the Women's Bureau and we said, put together a model policy for us. And so we're going to be doing that.